Sometimes people ask me whether it's a prerequisite, to file a complaint for divorce before you begin the mediation process. And the answer is it's not. You can begin mediating immediately without filing a complaint for divorce. But if you do that, you have to be careful about one thing in particular. Let's say it's January 1st and we have our first mediation session. Let's say that the mediation goes for 3 or 4 months and no settlement is reached. Now it's April or May. And we come back, we file our complaint, and you find out that your spouse over the last 4 months has incurred $20,000 in credit card debt, and now they're saying it's marital debt and you have to share the expense of it. Or let's say your spouse has taken your assets, which you saved all throughout the marriage, and spent them during that 4-month period. Wouldn't you have preferred to draw a line in the sand by identifying a date that we're going to use for the purposes of your divorce? And the answer is, of course you would. And that's why, if you mediate, it makes sense to discuss reaching an agreement, putting it in writing that says we're going to use the date that we start the mediation sessions as the end date of our marriage for all purposes related to our divorce. That way, you don't get burned by what happens during the months that take place during mediation prior to the filing of a complaint.